Raj?
నమస్కారం. తెలుగు సమితి సభ్యులకు స్వాగతం. మన తెలుగు సమితి ఈ 2021లో ఎన్నో ప్రోగ్రామ్స్ చేద్దామనుకుని ఎన్నో ఉగాది సంక్రాంతి ప్రోగ్రామ్స్ ని సక్సెస్ఫుల్ గా చేసి ఇప్పుడు మన సమితి సభ్యుల ఆవేదన మేరకు ఇమిగ్రేషన్ గురించి ఒక సెమినార్ చేస్తే బాగుంటుందని చెప్తే we have requested local immigration lawyer Mr. Andrew to give us a seminar. So ఇప్పుడు ఒక చిన్న పరిచయం మిస్టర్ ఆండ్రూ గురించి. ఆండ్రూ is the member of American Immigration Lawyers Association, really blasting regular updates in law and policy, is the vice liaison to the Memphis Immigration Court and the point of contact for the parole in place at Memphis USCIS organization. He also currently serves as the chairman to the board of Mid-South Immigration Advocates. Moreover, Andrew is the editor of the Tennessee newsletter for Bar of Association of Immigration Law and contributes regularly in a quarterly publication and synthesizes immigration options for the 11th court. So he's a local immigration attorney who can be approached by all of the community. He will give a generalized presentation of immigration. ఏమన్నా ఉంటే అతని తర్వాత కాంటాక్ట్ చేయొచ్చు. Saying that, Andrew, thank you and welcome to Telugu Association of Memphis. I hope you can take it from here.
All right. Well, thank you all very much. It is a distinct honor to be here today. When Srini asked me to come and speak to you all, I was almost blown away when he told me how large this organization was and is. And so it is a distinct honor that y'all have placed enough trust in me to invite me here today. And believe it when I say I have taken this presentation very, very seriously. So I'm going to be controlling the slides here. If there are any technical difficulties, somebody will let me know. It might not show up the same on everyone else's screen. So housekeeping and administrivia, this is required by my ethics board. General queries and questions are okay. Case-specific questions, I simply cannot answer them in a large group setting. That is not to say I'm not interested in those questions. It's just simply to say that I need to answer them in a one-on-one basis, which I am happy to do for anyone who has specific questions about any area, whether I'm covering it today or whether I'm not covering it today. I invite all of you to reach out. My contact information will be on the final slide, and I am approachable by anyone who wants to speak with me. General questions are okay. So general questions, feel free to type them in the chat box or to let the presenters know, and they will get them to me. The last point I want to make before diving in is that this is a large area of law. There are probably 300-400 subtopics, and I only have an hour to speak with y'all today. I've done my best to get broad coverage. I'm happy to do future engagements to talk about other topics that are not covered today, but I've had to make some judgment calls in what I've decided to put into material just because I can't cover everything. So again, if there is someone out there who's hoping to talk about a certain topic and I didn't talk about it today, that's okay. There's a reason. I'm just reminding everyone to contact me personally. We can talk about whatever you want. And with that said, roadmap. This is just the basic what we're going to talk about today. What I've discovered is the most important in my view. There's a universal concept I want to talk about. We're going to talk about path to a green card. We're going to talk about certain non-immigrant visas. We're going to talk about labor certification. We're going to talk about national interest waivers. We're going to talk about the I-140, the I-45, and other related topics. Okay. So with that said, employment-based immigration, there is a concept that everyone must know and understand. And trust me, it is easier said than done, because if you're not careful, you can violate status. And if you violate status in the employment-based arena, that usually means game over for your case. There are some exceptions, and we'll get into that. But the universal concept is stay in status. Do not violate your status, please. The clients of mine that are going through these processes, I am on bended knee. Please do not take any action or stop taking any action without running it by me first, so that way I can keep you okay with the government. So I've given you the sites right there. I promise you, if you go to the Immigration Nationality Act, sections 245, C2 and C7, you will see that if you violate status or fall out of status in the employment-based concept, in the employment-based arena, you could be ineligible for a green card, which would be bad. So please don't forget this, because This applies to everyone. It doesn't matter what your situation is. If you want a green card here one day, if you don't already have one, you're going to have to remember this. Now, there are two exceptions. And it's very important because I have actually gotten folks green cards because nobody took into account the exceptions. INA 245I and INA 245K. All right, INA 245I requires that a qualifying petition have been filed on your behalf on or before 30 April 2001. Okay, if you have a petition that old, then it doesn't matter if you've fallen out of status, violated status, worked unlawfully. Any of those things would be completely and totally waived if you had a petition that old filed on or before April 30, 2001. And that petition could be a family petition, that could be an I-140 petition. It doesn't really matter which it is. It could be a labor certification as well. It is important that you remember, hey, I have an old case. I wonder if it could help me out. The further we get on in time, the easier it is to forget the past. But just remember that that past could actually help. 245K is specifically directed at employment-based immigration adjustment applicants. It doesn't apply to family. It doesn't apply to diversity. It only applies to employment. And what it is, in essence, is 180 days of status violation that isn't counted against you. So just to give a quick example, let's say that you are on an H-1B and through some misunderstanding, maybe your attorney, maybe you, maybe your employer, you end up working unlawfully for 30 days. So what? When it comes to adjustment of status, that will not be counted against you because 245K provides a period of 180 days. And it's right here in the statute that I'm looking at, INA 245K2 has not for an aggregate period exceeding 180 days. So if you have fallen out of status, violated status, or worked unlawfully, as long as it isn't more than 180, you can still proceed with adjustment status. This is universal. I repeat again, there is nobody, and when I say nobody, I mean nobody, that is going to be immune from understanding this concept. So if you are going through employment-based, this slide is so important, which is why I put it first. By the time we get to the end and everybody's asleep, you will have remembered this slide. All right, so traditional NIV pathways. And I put here, if we had hours and hours, we could cover every conceivable method. But I'm focusing on the traditional, or what I consider to be the traditional ways, the ones that I see most often. Again, short time here with y'all. Wish I had many, many hours to spend with y'all, but I don't. So we can do future engagements, or again, for like time, please contact me. I'm not a scary person to talk to. I love people, and I always want to try to help. I'm from a family of immigrants too. So I may be born here, but I have a lot of family members that weren't. And I'm really, really passionate about helping. So if you have a question, oh, the student visa. Don't we all love this visa? Actually, it's a lot more complicated than it needs to be, which is why I'm putting it as the first. A lot of my employment-based adjustment cases that I end up seeing, a lot of them go through the student process. Okay, they go from F1 to H1B, and then maybe H1B to a labor certification, and then labor certification to an I-140, and maybe there's an AC-21 extension in there somewhere. It's a great pathway to go for the green card. So I would be doing a huge disservice to all of you if I didn't talk. Now, it isn't, in my view, this is going to differ from attorney to attorney, but it's very easy to get it. It's very easy. You need money and you need English. I mean, money isn't, I mean, this is America, guys. Money is never too far from the front of the conversation. And now it doesn't matter where the money's coming from. It could be personal funds. So you could have families that are going to be transferring money to your account. It could be scholarship or a grant that you've received based on your academic performance or some sort of essay you've written. Money is money. The university doesn't care what source it is as long as it's grant. And then you have to be able to speak English. And so they do require at least a basic level of proficiency. And you'll submit all of that along with your visa application. So they will ensure that when you matriculate at the university that you're able to do so in the English. Our favorite person, the designated school official, DSO, all right? The DSO, you should know everything about that person. You should know their name, their date of birth, their social security number, what they have for lunch. They're gonna be your go-to person for any questions that you have. And they certify the I-20 that the F1 non-immigrant needs to enter the country. People may be saying, how do I know where I'm registered? SEVIS, right? The Student Exchange Visitor Information System. And that is the N number that's going to be on your I-20. When you look at your I-20, you see all these different fields. Up at the top, it's going to say SEVIS number. And then there's an N followed by a bunch of numbers. So this is how the F1 and other visas are tracked by the government. And anytime you have questions, concerns, problems, they accidentally terminated your registration. You're not speaking to the DSO, or you're not speaking to your lawyer, who then can speak to the DSO. You are headed for problems because the DSO just doesn't care about what's going on behind the scenes. If you have a situation, for example, you've gotten into a car accident and you can't take a full-time course load, which you're going to talk about in a minute, and you're not talking to your DSO, that DSO is going to terminate that registration. And then you're going to have to talk about F1 reinstatement, which is an unnecessary headache if you can avoid it. So again, my goal here is not just to provide you with a bunch of information and just, talk for an hour or whatever. It's to get you to think how you can avoid problems. I go out of my way to help my clients avoid problems. And when you don't have problems, oh my goodness, the cases are so easy. And I try not to allow my clients to complicate their own lives. I put here, maintaining status is not difficult. People say, or even I've heard attorneys say, oh, this is very difficult. No, it's not. So easy. Full-time course load. Look at it. 12 hours of credit, 12 credit hours for undergrads. Masters is going to be a little lower, usually about 9. That's what it is at the University of Memphis anyway. If you need to look at what I wrote, these are just talking points on the slides, but we're talking about all of these right now. Talk to your DSO about a reduction to part-time. I had the example just a moment ago. What happens if you're in a car accident? Life happens, ladies and gentlemen. You could go from this engagement and go out to check the mail and you get plowed by a semi. Life can happen, but again, talk to your DSO. They will be there to listen to you and to help you if they can. And you say, listen, I'm in the hospital. I can't take a full-time course load. You can submit documentation and you can be in a reduced status in SEVIS that's still in compliance with law. Careful about employment. Now, this is serious. All this is serious. This is a big deal. We're going to talk about this in later slides, but I cannot stress to you how important this is. The F1 employment area is very intertwined with a lot of different topics. And if you don't keep it straight, again, what did I say in an earlier slide? If you have unauthorized employment, you could affect your entire green card case. That would be bad. Look at what it says there, D/S. What in the world does that mean? Well, DS means duration of status or duration of stay. Some people like to call it. That basically means this. Picture it in your mind. As long as you're maintaining status, your your stay does not expire. Okay, so you finish one semester, small break, go to another semester, summer break, go to another semester. If your degree program is 5 years, it doesn't matter. As long as you are maintaining, you get to stay. Unlike, for example, a visitor's visa, you know, Jose comes in on a visitor's visa from Mexico and is given 6 months. Well, at the end of that 6 months, if Jose isn't back in Mexico, he can be removed. In other words, deported from the country. So DS is a little different in the F1 context. And I put here the Guilford College litigation. Look this up if y'all don't know what this is, but in short, because this is a whole topic in and of itself that I can get really, really irritated about. But a couple of memoranda try to change the way unlawful presence is calculated for the F1 student. So a little bit of education here. There is no statutory definition on what is unlawful presence. It is not defined in statute. You can look, I promise you, you won't find it. If you find it, you tell me, because I don't know. So basically, the agency, USCIS, has come up with what it means to be unlawfully present. Well, for the student, this is kind of weird, but this is the rule. It says this: you are not accruing unlawful presence until an immigration officer or a judge says you are out of status. So even if you stop going to school, and this is serious, let's say I stop going to school, I'm on an F1, and I stop going to school, and then 5 years later, I go through another immigration process. That officer in that second process can tell me that I'm out of status as of that moment going forward. Those 5 years that I wasn't going to school, I'm still not accruing unlawful presence, because that is the way USCIS has always defined it. Well, the Trump administration, and this isn't a political discussion, so we're not going to talk about the former president, but during the Trump administration, there was a memorandum written to change how that unlawful presence is calculated. And Guilford College, among other parties, sued the Trump administration to stop that definition from changing, and they won. They won the case, and so the definition of unlawful presence for F1 students has remained the same, notwithstanding the Trump administration's attempt to change. Okay, F1 and employment. Now, this is where we really have to slow down, guys, because it's so easy here to be in trouble, to violate state. No off-campus for the first year. So for the first academic year. So August to somewhere in December, whenever your semester ends, then it picks back up in January, runs till May. No off-campus employment for that first year. And even during the school sessions, no more than 20 hours on campus, okay? Now, I have a but there, severe economic hardship. Now, what does that mean? Well, if we can, I don't know if this is going to show up here, but I have an example. Can everybody see that? You see that? Great. Okay, excellent. This is an example. Let's zoom in here. Employment authorization for Syrian F1 non-immigrant students experiencing severe economic hardship. Okay, so if the Department of Homeland Security decides to publish something like this, This is going to be in the Federal Register. It says here. Now, this was published Thursday, April 22nd, 2021. So it's very recent. And this basically is a suspension of the normal rules. And the normal rules being that you cannot have any off-campus employment during the first year, and you can only work 20 hours per week on campus for students. And you file basically a I-765 application for employment authorization, and you get exemptions from these rules. Now, if I can figure out how to go back, that would be awesome. Okay, so, but I said also there are other examples. There's also one for Venezuela, all right, and there's also one for Myanmar or Burma due to the military coup that took place in February. But just note, if there is severe economic hardship, you can avoid these general rules up at the top. Now, other employment. Everyone knows these, well, should. CPT, OPT, STEM OPT extension, all right? CPT is gonna be your curricular practical training. It's done during your studies. And what ends up happening with CPT is it can be full-time or part-time. And it's noted on your I-20. So when you want to apply for CPT, you would go to your DSO, you would need to submit a letter from whoever would be the employer, and it would be noted on your I-20, normally on the back where it says endorsements or employment, and it would be listed CPT. Now, here's the thing with CPT. If you pick full-time CPT, then you would become ineligible for OPT, which is post-graduation. So with OPT, you get 12 months of employment authorization related to your degree field. And you get 12 months at each degree level. So 12 months at undergraduate, 12 months at master's, 12 months at PhD. But going back, make sure you connect this all in your minds. If you have already gotten 12 months of full-time CPT, you're ineligible for OPT. So you always want to get that part-time CPT, because part-time CPT doesn't matter. You can have as much part-time CPT and you can still get OPT. And I know that I've done it. So I know it is because I do it in my own cases. So I did have I did have another point here under OPT, and that's the unemployment period. The purpose of OPT is for you to be working, but if you go unemployed, as long as it's not for more than 90 days, you'll be fine. But if it is for longer than 90 days, then it's an immediate departure from the country. Usually, as we know, after F1s, you have a 60-day grace period. You don't get that grace after you've had that much employment. And I've also seen that firsthand. So just remember, a lot of people, unfortunately, don't take this into account, CPT versus OPT. Some DSOs will mention it to the student, and I've actually seen that happen. Other DSOs won't, and they'll just say, oh, you want full-time CPT? Sure, here it is. And then by the time you've gone through your 12 months and you're ready to apply for that OPT, oh, it's denied. So whenever you're looking at CPT, check with an attorney, check with your DSO. Again, anything that you want to do, make sure you're fully informed, because once it's too late, it's often not fixed. STEM OPT extension. All right. What does that mean? Well, let's find out together. This February 1st, 2021, this is a broadcast message listing at this link here where my mouse is, STEM designated degree program list. And then you can click on this list. I'm going to get too deep into this, but if you click on this list, it has the full list of, I think it's 13 pages of the codes and what the degree is, what the degree program list is. And if you are in that list, then you can get an additional 24 months of employment authorization. And because you get the STEM OPT, if you get it, then your unemployment period goes from 90 to 150 days, but it's including any unemployment from initial OPT. So for example, if you have initial OPT and you were unemployed for 15 days, and then you get STEM OPT, well, now you reduce 150 by 15 and you have 135. So just note that it's not 150 days on top of 90 to make it 240. No, it's 150 total. And so just take into account any unauthorized employment you had from initial OPT. Now, this is a thorny question in my opinion. You're an F1 student applying for adjustment of status. Can you work on a C9 EAD, which is the employment authorization card that you get while your green card is pending? What if you're signing a new I-20? Every time I ask this question to my own colleagues, I get answers that are all over the place because the regulations and statutes aren't clear. One practitioner might say there's no violation of the F1 status because the work authorization is completely separate from that. It's a separate case. When you apply for adjustment of status, you are authorized to work. So how is that a violation of your F1 status when another case allows you to work? That's one side of the argument. The other side of the argument says your F1 employment authorization is CPT, OPT, STEM OPT, or severe economic hardship like we looked at for Syria. The C9 EAD is not that. So you're violating your status. Now, what does the I-20 have to do with anything? Well, if you sign a new I-20, you certify that you are complying with all the F1 rules and regulations. So there's a thorny question there. If you sign a new I-20 that says you're not going to engage in any unauthorized employment, and then you work on a C9 card, have you committed fraud? Have you just lied on your I-20? Again, in my experience, this is going to be a practitioner by practitioner question. I just had this conversation 2 weeks ago with a small group in my own professional network, and there were heated opinions on both sides. And so in my view, this is an open question. So you would want to be safe if you're asking, Andrew, how can I be safe? Don't apply for the C9 card and just stay on your student visa, right? And then if you get a green card down the road, you don't have to worry about it. That would be the safest, but some people have to work for whatever reason. So just keep in mind that this is out there, and in my opinion only, I don't speak for every lawyer in the United States, but in my opinion, it's an open question. And every time this comes up in my professional circles, we argue about it. Traditional pathway number 2, the H-1B. All right, we can really spend all day on the H-1B, but we can't. So basic requirements. Highly specialized knowledge, we all know that. Bachelor's or higher is a minimum to work in the field, okay? And I note minimum, okay? It doesn't matter where you're going. Oh, I'll eventually get there. Well, maybe I'll get there later. Doesn't matter. It has to be a floor, right? It has to be a floor, okay, to work in the field. And you must satisfy one of these, okay? These 3 bullet points. U.S. bachelor's, sufficient foreign equivalent, or an unrestricted state license registration certification. Now, let's look at that second, sufficient foreign equivalent. Well, what is sufficient? Well, you're going to have that education evaluated for the U.S. equivalent. It's sort of like changing currency, right? How much is the British pound worth in American dollars? It's the same thing here. We have person X with this foreign education. What does it translate to in the United States? And then it has to be at least the equivalent, right? US bachelor's, it'll say what the US equivalent is. And if it equals, for example, US bachelor's or higher, well, then you've met the requirement. Right? Now, don't forget the LCA, the labor conditions application. You have to have that along with the I-129 when you file for the H-1B. And you might ask, well, what's the LCA? Labor conditions application. It is what it sounds like. It's just discussing the labor conditions that are going to be present in the employment. Working environment, strikes, wages, time off, medical leave. What is the employee going to be stepping into? And that has to be certified by the Department of Labor. And there's another slide that talks about the LCA in greater detail. But just note, the employer must file that LCA. It has to be certified by the Labor Department as a precondition to getting an H-1B. Cap and duration, okay? We know the regular cap, 65,000, 65K, right? 20K additional are exempt from the regular cap if you have a master's or higher from the US school, okay? So just note that if you're not under the regular cap, maybe you'll be one of the 20K that are additional 20K that are exempt from that. Usually 3 years, initial status with 3-year extension. So you have your 6-year max. If you don't switch to any other status, or if you don't do anything else, well, then you're done. You need to wait a year outside, and then your period starts over. And some people don't want to become permanent residents here. Some people just have their H-1B. They're happy working here for a short period of time. Maybe they can make a lot of money and then go back to their home country. People do that all the time. Years ago, I worked with a family that did just that. They said it initially. They were not interested in US permanent residence. They did their 6 years and they went back home. There's nothing wrong with it. I'm just saying 6 is your max. 3, usually 3 and 3, that's it. AC-21 extension past 6 years. Wait a minute, but I thought you said you can't extend it max of 6 years. Well, it is. But if you have other circumstances, you can extend past 6 years. AC-21 is just a fancy abbreviation because I didn't want to crowd the slide. But AC-21 is the American Competitiveness in the 21st Century Act. We abbreviated AC-21. So there are 2 separate sections that you can extend that H-1B, 104C and 106A. 104C, I-140 approved, but PD not current 3-year extensions. What does that mean? So if you have your I-140 approved, but your category and your country is backlogged on the visa bulletin, which we will look at shortly, then you have to wait for your visa to become available. Every single month, the Department of State releases a new visa bulletin with all the movements of the numbers. So if you are waiting for your visa to come current, however long that's going to be, you can get up to 3-year extensions for your H-1B. I had a longer slide, but I took some of the material out. But the other point I wanted to make about this is the regulation seems to discuss this as a one-time extension, but it's not. And the agency has said as much. It can be multiple 3-year extensions back, to continue as far as you need it until your priority date comes current. So I think it's important to note, because when you read something, you expect it to mean what it says and say what it means, but that's not it here. So I don't know why, honestly, I'm not going to lie to you. I don't know why it was written in such language that makes it seem like it's a one-time thing when it's really not, but that's how it was. 106A is 365 days past since either filing of the perm, right? Perm is a labor certification, we'll get to that. When that's required, some people, remember, like national interest waivers don't need a perm, or the I-140. So if you have either one that's been pending for at least 365 days, you can get 1-year extension for the H-1B and past the 6 years. So just keep in mind that if you have an option under AC 21, 104C, or 106A, you can go well beyond the maximum that would otherwise require you to leave the country after. H-4 dependents, we talked about H-1Bs, but the H-4s are the family members, spouse and child. I encourage everyone to take special notes. Spouse and child, we say in our daily lives, these relationships are defined in the law. If you go to the Immigration and Nationality Act, Section 101A35, you're going to find the definition of spouse. Section B1, definition of a child. When we say spouse, we say child, it has to be as defined by the immigration law. The H-4 is subject to the same 6-year maximum, which makes sense, right? That makes perfectly good sense for a 6-year maximum to apply to the H-4 dependent, because the H-4 dependent rides on the H-1B. So it wouldn't make a whole lot of sense for the H-4 to be able to stay here longer than the H-1B principal on whose application the family member is dependent. Employment authorization for certain H-4s. This was a relic of the Obama administration. It's for certain H-4s. I've lost count how many consultations I've done for individuals on H-4s looking for employment authorization, and I look at their case and I go, I'm sorry, you don't qualify for it. So these are the requirements. The H-1B principal must, and I capitalize must because it is an absolute requirement. It's not open to interpretation here. You must have one of these things. The H-1B principal must have an approved I-140 or have received an H-1B extension under, let's go back, 106A. You see there, 106A, 106, well, A and B, they work together, but it's the same thing. So if you don't have one of these two, your H-4 can stay here and go to school and be good and totally fine in status, but cannot apply for an EAD. Okay, and again, this makes sense here. If you get the H-4 work authorization, it terminates with the H-4 status. That just makes sense. Okay. Now we're changing topics now from temporary to permanent, the labor certification. This is basic information, but you'd be surprised how many folks go right past this stuff. Filed with the Department of Labor's ETA, Employment and Training Administration. The form is ETA 9089. The burden is on the employer. Okay, this is the employer going to the Labor Department and saying there are no able, willing, qualified, available U.S. workers to do this job. And because of that, I need this person to come in and do the job for me. Okay. And we have the labor certification because, you know, this is the United States, and the policymakers in our country, the Congress and presidents from from years past, they want to ensure that American workers are not going to be displaced, wages aren't going to be impacted, working conditions aren't going to drop. What do you mean by working conditions? Well, maybe immigrants, and this isn't to sound nasty or anything, but maybe an immigrant is fine working in dangerous conditions because they have to make money. Well, that's not cool. Everybody should be able to work in a safe environment. So they want to make sure that the immigrant employment arena isn't bringing down the safety of the conditions of U.S. That's the purpose of it. And then money, money, money. Please do not play games. I'm not trying to lecture anybody here. It's not what this is. This is a serious point. The employer must pay all costs. Okay, any lawyer, advertising costs, anything. And some people come up with creative solutions, and I hope you will indulge me in a little aside from our material, because I want to tell you something very important that was very serious that happened to me. Well, I gave this same spiel to an employer, and behind my back, what ended up happening was the employee, right? I'm sitting here next to someone right here on this screen. So this person's going to hand me money. I'm going to put the money in my pocket, pretend that it's mine, and I'm going to take the money out of my other pocket and give it to the government. You can't do that. The money has to be original. It's got to be my money from my pocket. And if you don't have what's called, original money from directly from the employer, and you get audited by the Labor Department, oh, are you going to have fun? Okay, and this is serious. There can be serious consequences for the employer. Please do this the right way, y'all. If it costs money and the employer doesn't have it or doesn't want to pay it, with all due respect to anybody watching this, is that employer really interested in you in the first place? I don't think so. If that employer isn't willing to pay whatever needs to be paid, that employer might not be that interested in you. Okay? So please remember this. It's very serious. All joking or lightheartedness aside, this is real stuff. You need to seek the prevailing wage determination from the Department of Labor in advance. Now, why? Let's go back. Remember that wage comment? See that here? To ensure the admission of foreign workers will not displace blah, 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 and affect wages. So wages, right there again. Seek prevailing wage determination, okay? The Department of Labor will say the prevailing wage for this job is $57,212.19. You have to be able, or the employer has to be able to pay that much money to the employee so that American workers' wages are not adversely affected. So you see it all ties together. You have to write the job description. This is an art, okay? The job description has to be generally written, okay? It has to be able to encompass other people to apply for the position. If it is so narrow that nobody can fit it except the gentleman sitting to my left, then again, I'm playing games. I'm not, again, look, go back to the slide again. displace American workers. If I write my job description so narrowly that my buddy here is the only one who can apply for the job, then I am displacing American workers by not giving them a chance to apply for the position. So this isn't just take 5 minutes, jot it down on the ETA 9089, that's the form, and send it to the Department of Labor, because they're going to come back and just laugh all over you. This sometimes goes through, I spoke with a colleague of mine at a conference a year and a half ago, and she told me that she writes the job description at least 10 times for each case until it gets perfect where it needs to be. She'll talk with experts in the field. This is how down in the weeds this can get. She'll go to people in the field. So for example, if it's mechanical engineering, she'll go to actual mechanical engineering firms and speak with mechanical engineers to get a description of the job. So you definitely want to do your research here. And whenever I think about how I'm going to write a job description, I don't even have a first thought. I'm just like, talk to me about what the job is and let me write everything down and then I'll figure it out. Because otherwise, because writing it, you're going to end up changing it a dozen times, like my colleague told me. You advertise and review. Now, what does that mean? Okay, well, I'm using my buddy here because he's right next to me, so I always want to talk about him. So let's say we advertise and I get 65 resumes. Well, I've got to review all of them and be able to describe why I rejected them. So if we put my buddy here, my other buddy over here, and one is an American and one isn't, and they all have the same qualifications, who gets the job, right? Remember, go back to this: able, willing, qualified. If there is an able, willing, qualified, and available, I should never leave out available to work, then your purpose has not been met, and the labor certification will not be approved. So you have to complete these ad steps at least 30 days before the filing with the Labor Department. So your advertisements need to be all done well in advance before you send off that ETA 9089 online with the Labor Department. And you better, I say better, I'm not trying to be a jerk about this, but you better make sure you have a good reason for rejecting all of the applicants. You cannot do it after the fact, because again, look at that slide above there. Please do not play games, okay? You should be able to interview all the candidates. You should be able to talk to each person or review their materials, whether it's a CV, an interest letter, whatever it is, and be able to justify competently and professionally why you turned the person away. And as long as you can do that, you're good. Even if they audit you, you'll be fine. Because you can go to Jack Smith, John Smith, Jane Smith, Billy Smith, Rachel Smith, all the Smiths, and you can explain, I turned away this person, not enough education. I turned away this person because this person isn't a team player. They were defensive, they were nasty in the interview. I turned away this person because this person doesn't have the certification required for the job. I turned away this other person because they can't work remote. They have to work in a certain place and they can't travel for the job. Whatever it is, they need to be able to explain what it is that is wrong with the applicant. If certified, 180 days to file the I-140, which we're getting to next. So if it's certified, it'll be down at the bottom. It'll say certified from this date to this date. And within that period of 180 days, well, we'll get to I-140s in a minute, national interest waivers. For placement into the EB2 preference category, okay? So the national interest waiver, it gets around the labor certification requirement from the prior slides, right? Labor certification, so you're getting rid of that one. Now, it's not defined by the statutes. You cannot go to a statute in the Immigration and Nationality Act and find the following people qualify for national interest waivers. It's not there. Again, if you find it, call me up because I haven't. So we basically have a law, if you will, but it was given to us by an administrative body called the AAO, Administrative Appeals Office. Anybody that knows anything about national interest waivers knows matter of Afghanistan. Okay, and that is the official site there for anybody that wants to look it up. But for you, I've already looked it up for you. So let's look at the standard. USCIS may grant a national interest waiver if the petitioner demonstrates that the foreign national's proposed endeavor, and here it is, substantial merit and national importance, he or she is well positioned to advance the endeavor, and that it would be beneficial to waive the job offer and labor certification requirements. So this, now, there's a lot more to it, but I'm saying this is where you always start your research. And there have been some deviations from DANISAR. There have been some additional case law has developed, but it's just like anything when you research. Whenever I research cases, you start with the main case and then you work down through Lexis or Westlaw or whatever it is you use for your research and try to make your argument. But I always start with DANISAR. DANISAR is a big deal because it was a big change, and we can see that if we go back to DANISAR, look at the case that it vacated. Y'all catch that? Matter of New York State Department of Transportation. Look at that date there, 1998. So the law that was in control was in place from 1998 almost to the end of 2016. So that was a big change. So that's why this is such an important decision, and everyone should start looking at DANISAR for any national waiver question. Now, if it's approved, the I-140 can be self-filed, obviously, because it's waiving the requirement, which leads us to the I-140. This isn't a bit, well, again, this is a little bit of editorializing here. In my opinion, it's not a big deal because the I-140, I think, is only like 4 pages of information. The other 4 pages are all the various signatures that you need. But the I-140 is not a big deal. The employer files on behalf, and look at this here. I mean, I'm skipping around a bit, but for the employer filed I-140s, either employer or employee can pay the I-140 filing fee. So if my buddy here wants to give me $350 from his own pocket, I can take it. It doesn't matter who pays it. Okay, it can come from anywhere, any well, legal. I mean, if you've got your marijuana farm, probably not a good idea to be selling it and paying for your filing fees here. As my buddy here is laughing at my joke. So just be careful. But just in all seriousness, it can come from either side. Unlike the labor certification, where I told you a couple of slides ago, please do not play games. The employer must pay all costs. So just remember that. What's the big step here? Open up the books, right? Remember that prevailing wage determination? We go back, seek the prevailing wage from the DOL. Okay, great. Now the employer really has to show that the employer can pay the wage. And how do you do that? Well, what about taxes, bank accounts? If the employer can show the solvency, then the employer should be fine. But if the employer is a startup company with $2.12 in the bank account and the prevailing wage determination is $67,848.09, the USCIS officer is going to go, with all due respect, Mr. Employer or Ms. Employer, how can you afford to pay this person not such little money in your bank account, and your tax returns don't show a whole lot of money being earned here? It shows a big loss, but not necessarily a big profit at the end of the day, a net profit. So we usually use taxes, again, bank accounts, any holdings of the company, how they pay their bills, are they behind on any debt, anything to show that the PWD can be met year after year after year after year. Okay, and then this is also priority date. This final slide goes back to AC 21. Okay, we go back to AC 21. We talked about I-140 approved, but PD not current. AC 21-104C. So if we go back to this slide, the priority date is the date the labor certification was filed. Okay, so when the Department of Labor receives the ETA 9089 and it is officially received, it's filled out correctly, it's digitally signed, all of those things, then a date is given to it. This is the date in line. That is the same date that goes on the I-140, okay, for those cases that need a labor certification. For those that don't need a labor certification, well, then the priority date is the I-140 filing date. And we find this on the visa bulletin. So if we look, this is the visa bulletin for next month. This bulletin was released yesterday, so it's hot off the presses. And there's a lot of information that, it doesn't matter. What matters is if we go here, employment-based preferences, you see that? I'm highlighting it. Employment-based, well, I'm not doing a very good job. There we go. Employment-based preferences. Okay. Final action dates. This is the chart. There's another chart below that's a little beyond really where I want to go with it, but these are the priority dates. If you have a C here, that means it's current. The visa is available right away. But if you have a date here, if we look at India, for example, in the third preference, the cutoff is 1 January 2014. So that means that only petitions that were filed earlier than that date, so December 31st, 2013 and before, are eligible for processing. So the visa bulletin is very important because it shows you where you are in line, and also it can really affect for your H-1B holders, the AC-21 extensions. So continuing on here, getting close to the end here. We have the adjustment of status. I'm not going to spend a lot of time on this. This is pretty straightforward. We've already covered the difficult stuff. So the main steps are the medical exam and then the supplement J for those who need a labor certification. The supplement J is just the confirmation that a bona fide job offer exists. So if I'm an employer and I'm filing for my man over here, let's say 6 years have passed because he's waiting on a priority date. Remember, we went back to that visa bulletin. That visa could be 6 years. Look at that date, 2014. So if the visa bulletin moves month after month, you could be looking at a 5 to 6 year wait. Sometimes you'll get multiple jumps. You'll get a 3-month jump or a 6-month jump, but you could be looking at several years. Maybe in the interim, the business is closing, or maybe in the interim, my guy here has misbehaved and I had to fire him. Well, then there's no more job. I'm not going to employ him if he's done bad things. So the supplement J is the confirmation that the job still exists. The rest of the stuff is not a big deal. You have to show you maintain status. That's not a big deal. You have the I-864, which is the affidavit of support. It's usually not required for employment-based cases unless there's a family relationship. I've actually, I'm not even gonna lie, I've never had to do an 864 for any employment-based case ever in my whole career. Even before I was an attorney, when I was a paralegal or a law clerk, I never even had to work on a case with that. I'm sure plenty of people have, but I've just never seen it because it happens so. Now this is serious here. COVID restrictions. Y'all got to be careful with this. because these bans are still in effect. I just wanted to note them for you here. President Biden, unfortunately, this isn't President Trump's carryover proclamation. This is President Biden's original proclamation from April 30th for India, but it's a non-immigrant ban only, okay? And how do I know it's non-immigrants? Because if we scroll down, suspension and limitations on entry, the entry as non-immigrants. See that right there, okay? And then we see here, President of the Republic of India, okay? So it isn't as broad as the other COVID bans. So that's good for the Indian nationals, but it's also bad because it still covers a lot of immigrants. H-1Bs, F-1s, these are all non-immigrants here. Okay, but look at the number of exceptions here. You've got 13, I think. There's 9. Here's 10. Here's 11. 12. 13. No, 12. Okay, so you have 12 exceptions to the ban. This is extra information, okay, and it's a little, it's not really NIV processing, but I did want to let you know that there are still other bans out there for travel purposes, right? So you don't want to travel through any of these countries, the Shenzhen area, the UK, Ireland, Brazil, and South Africa. So the Trump administration terminated these bans, and then the Biden administration like resuscitated, brought them back. So this is all about where you can get flights. You don't want to travel through any of these countries. You don't want to go through Heathrow. You don't want to go through Charles de Gaulle in Paris. You want to go through like Argentina. You want to go through like Costa Rica, Mexico, Canada. So, I say this jokingly, but it's really just about musical flights. Where can you get planes to not travel through these countries, to not be impacted by these bans? Because it only talks about, if we go back to the memo, to the proclamation, we look at section 1, it says physically present within the Republic of India during the 14-day period preceding their entry or attempted entry. So all we have to do is just make sure that you're not present in this country 14 days prior to when you want to come in. So it is important to note that if you have your visa and you're wanting to avoid these travel restrictions, it's about where you can get flights. National interest exceptions, NIEs, okay? This is a broad way to get around the COVID-19 travel bans. So if you have an NIE already approved, there's some good news. This is breaking news. This came out Thursday. Yeah, August 12th. If we look at this, this was last updated August 12th. This was originally June 29th, but it was last updated August 12th. If you have an NIE that's approved, it will be valid for 12 months from the date of approval and for multiple entries, so long as they are used for the purpose for which they were granted. So you can't change the purpose for the NIE, but you can come in and out multiple times for 12 months. That's good. Now, applying for the NIEs either through the consulate or the embassy, or in exceptional circumstances directly with Customs and Border Protection. The link here discusses additional information on the NIE. It talks about students and M1s. It's just general stuff, but it's a good place to start your research if you are interested in an NIE. But it's easy. It's better to go through the consulate and embassy. From what I've heard, I've never done one through CBP because I've never had one come up. But a practitioner told me that a CBP NIE is a one-time approval, and you have to use it within 30 days. After that, it's no good anymore, and you have to start all over with that process. Whereas the NIE through the consulate and embassy is for a longer period, as we just saw, 12 months, and for multiple entries. CBP is only one entry. Now, that is what actually several practitioners told me that. I have never recommended it. I've never had a situation where I would consider recommending that. So just be aware that in exceptional circumstances, you could come to the port of entry or through the pre-clearance, CBP pre-clearance, and apply for that. Now, this is kind of the government not really thinking, what's the workaround for the Department of State? Well, leave from India, go to Guatemala, stay there for 14 days, and then get a visa in that country as a third country national. Apply for a Guatemalan visitor's visa because that's easy to do for someone who's not speaking Spanish or anything. Figure that out. It's going to be fine. It's not fine. I say it jokingly, but it's very sarcastic. You can tell. This is not as easy as the Department of State is making it out. I'm having to contact lawyers in other countries because they're like, hey, Andrew, how do I get a visa in Nicaragua? I don't know. I'm not a Nicaraguan immigration attorney. I have no idea. So I've got to call my buddy, who then calls another buddy. And then by the time we get around to somebody, yeah, we can figure it out. But that's what they say you have to do. You leave from the country that's subject to the ban. You stay there for your 14 days, you get your visa, and you come in from that country. So the Indian national flies from Guatemala City to Atlanta and then gets inspected in Atlanta. There is litigation pending in the district court to undo all of this. If anyone is interested, like me, because I'm nerdy like this, Kinsley v. Blinken, the Secretary of State, Anthony Blinken, I think that's Blinken, I think it's Anthony Blinken. It was filed on April 7th in the DC District Court. I gave you the case number there if you want to look it up. Basically, it is, briefs have been filed, but no resolution as yet. But I did want to throw it out there to know that lawyers are litigating this stuff. Again, because of how sarcastic I was with the workaround. This isn't as easy as people are making it out to, or as the State Department is making it out to be. And in fact, in my own cases, clients call me up crying from their third country because they're alone, they don't speak the language, they have no idea where they are, and I'm having to try to, be a shoulder for them, but at the same time going, I'm not there with you. And it's only 14 days, but then you have to apply for the visa, and some countries are going to take, different levels of time to approve your F1, your H1B, whatever it is that you have that you're wanting to use to come to the United States. So again, not as easy as the government's making it out to be, but that's what they say you can do. LegalNet, this is another important thing. It's not an appeal, but it's similar. So if you have a denied case and you're thinking, well, they got the law wrong, not about fact, it's about the law. They made a legal error. Then you can email legalnet@state.gov. I gave you the site there in the Foreign Affairs Manual, FAM, 9FAM 103.4 procedures on how to email LegalNet. And basically, they will review your case and get back with you. I've got numerous bad decisions by the consulates and embassies around the world overturned by using LegalNet. And it can be with an attorney, without an attorney. Obviously, if you're not using an attorney, you have to know how to make legal arguments. But it is out there, and I always tell people, use LegalNet if you think that the consular office got it wrong. Final slide before we see if there are any general questions here. We have, this is my contact information. I repeat probably now for the 5th time, specific questions, please. I'm happy to talk to anybody listening or watching this. I want to meet you. I want to get to know you. I want to see if I can help your case. I want to see if you're on the right path or if there's a better path. I'm giving you my cell phone, so that should tell you something. If you call that number, it's on silent right now, but a phone is going to ring in my briefcase right now. And my email address, my man here knows is real because we were just using the email address before we started this presentation. So reach out to me by email, call me on the phone. If you want to make an appointment, obviously, please don't just show up because I may be in court or whatever, but that's where my office is. It's a real office building. It's not a, not a phantom office. I really do work there. And I would love to meet anyone who would like to talk with me about the case. So with that said, I am done, and I'm going to turn it back over to the hosts and the presenters. I'm going to stop my share.
Yeah. Thank you, Mr. Andrew, for taking time and given us information. I mean, I'm sure everybody who has gone through your slides must have already know that this has really been to. So as you might already know, there are viewers on YouTube, there are viewers on Facebook, and we have a few up here on Zoom where we're logged into. And we are getting a few questions, and I'd like to ask them one after the other. So the first one is there any process in place to interfile I-6983 medicals? This is for the adjustment of status though. Or do they have to wait for an RFE?
That is a great question. And you know what? It's a general question. I can answer this. I'm so excited. Got it. Yes. The answer, okay, so this is how it's going to go. So to the poster who wrote that, thank you for your question. I'm going to go a little slow in case you want to write down what I say. I'm on mute. Yeah. So let me answer this. USCIS policy is do not, and I repeat, NOT, interfile unless you get an RFE. Okay, I repeat that again. USCIS's official position, and trust me, I've seen it 150 million times, do not interfile it. Either wait for an interview notice or wait for an RFE. Now, let me say this to you as a general strategic question. Now, this gets advanced, but we're here to talk about the law, so let's get into it. There is a strategic question in your question. Do you file your medical exam early, or do you wait and bring it to the interview? For employment-based cases, I always file them with the package, because under the Biden administration, I am seeing fewer interviews being set for employment-based cases. So think of it this way: if you're not going to have an interview, then you're going to get an RFE saying, "Hey, we're not going to interview you, but we don't have the medical. We can't approve the green card without the medical." But if you already have the medical in the file and they're not going to interview you, approval. So be very careful in just saying, "Well, I'll just do it later." You can do that but if you cause a delay in your case, you would be sad. So under the Trump administration, I was doing my medicals later because he was interviewing everybody, and you all know that. But now with President Biden, I'm seeing some EB adjustment interviews, but not as many as under President Trump. So I am telling my new cases, hey, do the medical now. Worry about it. That's the long answer, and that, in my view, is the correct answer.
Thank you so much, Mr. Andrew, for giving us a detailed explanation on how we should be doing our medical school.
Yes.
The second question I got here is it mandatory to stay with the same employer for 180 days after the I-140 is.
No, because it can be ported. So that gets into portability questions. This is interesting. So I would go up to a point, and then it's going to get kind of case specific.
Well, this can be either with reference to adjustment of status.
Yeah,
It could be a downgrade scenario, or in a regular scenario when they're in the process of applying for leave pension
in the I-140, right? So I think the best way to answer this one is to give you a real example of how I did this. So what's important for that question is, first of all, no matter what your scenario is, it has to be the same or similar field in order to port to a different employer. That's where you can run into issues. And not only issues, you run into denials. They'll say, you cannot port this. You cannot port this. So the first step I would always say, this goes back to the advice that I gave at the beginning, talk with your lawyer, thinking about changing jobs, or if your company says we're merging, we're diversifying, if there's any change at all, on your side or the employer's side, you better run to the lawyer. All right, and when I say the lawyer, remember, your employer may have a different lawyer, and that employer's lawyer is meant for them. And they're going to make sure that their company's best interest is protected. When I say the lawyer, the employee's lawyer, run to me, run to your lawyer. And then we need to compare the two, where you are and where you want to go. And then usually I conduct research. I usually call up, again, experts in the field. I usually call up people on the ground in that new field. And I say, is this sufficient? I usually get opinion letters. Okay. Opinion letters would be a good thing. And then if it's portable, then you can switch to the employers. I usually require, at least this is just me, and I know I'm getting a little bit more specific, but my policy, I usually require some sort of opinion letter from someone in the field, not just my own research. And unfortunately, and not client, but that's usually paid. And that just use that to strengthen my arguments if I have something from the field. So the answer is no, you don't have to stay with the same employer, but there are a lot of steps involved. So please be careful before you take any steps, run to your lawyer.
Thank you so much for the answer, Mr. And one other question that I have up here is, if a person works on two jobs simultaneously for a brief period of time, 1 or 2 months, say for instance, while they are on their STEM OPT, and then stops working for one of the two jobs that they were working for, should an I-20 that they carry with both companies be listed or be issued? So accounting for those 1 or 2 months.
I've done this.
Okay.
I immediately, when you were about halfway through the question, I knew exactly what you were going to ask. When I first encountered this, I spoke to the DSO of the school where the STEM OPT had been authorized. Okay. Now the DSO said that it was highly recommended that both be listed. However, legal counsel in that school said it wasn't mandatory. So this goes into more of a best practice. It's the only time it ever came up in my practice. It only came up that one time. But we had a long discussion about the benefits and the disadvantages of doing that. And ultimately, it was decided that the best path is highly preferable to list both employers and to note that that the other one is a temporary assignment or project. In my particular case, it was a consultant. My STEM OPT individual was a code writer for websites and high-tech stuff. And the project was going to be a one-time deal to create a mainframe for the company. And it was going to be over. Once the project was done, he stayed on with the first company. They were going to farm him out to the second. Because it was a date certain of start to a date certain of end, we felt it was best to write it into the I-20, and the DSO had no problem doing it. The DSO said, and this particular DSO had been doing this for a long time, and she said, do it. So that if I ever have this situation come up again, that is what I would say, unless somebody could bring me a reason that maybe we shouldn't. Of course, we would look at that case by case. But again, you see going back to the slides, what did I say? Run to your DSOs. Don't ever leave the DSO out of the loop, because some of those DSOs, and I am not even ashamed to admit this, some of these DSOs are smarter than me when it comes to this. And I've had attorneys say that to me, attorneys who work with F1s all the live long day, for example. They say, this person could be a lawyer tomorrow if they went to law. And so I run to the DSO, because also that DSO manages CBIS. And where is CBIS connected? And what does ICE do? We know what they do. Right. So that is what was recommended, and that is the reason why. So keep that in mind for that.
Yeah. There's one more question.
Yeah.
There's one more question that they were asking is that for H1B 6 years, they still not get their labor approved. Can they go on to a H4 visa?
No, because the same thing applies. The same time applies.
Time applies. So
Yeah.
H1 visa, they cannot.
Yeah, if I'm understanding the question correctly, yeah, it's the same maximum applies.
The labor is not approved. They can.
Right. Well, not necessarily, because remember, the labor doesn't have to be approved. Remember, if it's pending 365 days, remember that.
Yeah.
If under AC 21, we go back to the slides, if the labor certification, the PERM, the ETA 9089, it's been pending for 365 days, you could extend the H1B past the 6th year.
Yeah. Okay, I think this particular, they were waiting for labor to be approved for the 6th year. That means the 365 days are not.
Okay, right. So continue the clock. Most, to finish the answer to that, yes. So if the clock hasn't run, obviously you can't do it. But if once it has run, then you can extend the H1B path.
So if in case not 365 days before that labor is applied, clock has run out, they can't move to it.
Right, yeah, because it's the same, and that makes, because also remember, and this is assuming they can't move to H4 unless their spouse is also on an
Yeah, their spouse is on it.
Okay, yeah. So I just wanted to clear that up.
Yeah.
In order for them to move to H4 in general, the spouse has to be on H1. And then
Their H1 is expired six years.
Yeah, I think I'm understanding the question correctly. No, it's the same 6-year max. H1B and H4, they ride together on that. If I'm not understanding the question as it's being asked, we can clarify through email.
Yeah,
If I'm,
I will give them your contact.
yeah. If I am, I think I'm tracking it right. But if I'm not hitting the point that the questioner is wanting, again, reach out. We can smooth it over in.
There's one last question.
Yeah, what's the last one?
Last question is in a EB3 down date, I-140 is still pending My EB2 is correct from last bulletin. So is the I-140 premium processing or EB3 gets rejected by USCIS 3 times? Is there a way to go back?
That has not come up in my practice. Have them contact me offline. I can get an answer to that. I have not had that scenario come up. That is very interesting. Could he go back to EB2?
As long as he's done a downgrade on a new case, could probably go back.
I would think so, but I have not had that specific issue come up. And because the downgrading is kind of a new thing.
I mean, it's been there. I mean, when I did get a chance to talk to a lot of attorneys when we were actually going through the same process, they did mention that it has been a practice for other nationals.
Used to happen for the
Chinese nationals,
Yeah, the Chinese
all of them. So that's not in the new trend after October of last year.
Right, after that, right. Yeah, when folks were working until 3, 4 in the morning, getting the filings out while the numbers came current. Yeah, it's just for Indian nationals. I've not had that come up yet. So yeah, have them reach out individually. That's a great question, and it's also important for me because I want to know the answer to that as well. I would probably need to go back to my other downgrade cases and see the difference there.
Sure.
But that's a great question. Let's do a one-on-one.
So I have one other general question.
Yeah.
Thinking is general.
Go for it.
But so based off of October's bulletin and the way that it has been progressing over the last couple of months, or maybe for the last 8 months, been there, none of the files have been moving over the 140. Every downgrade. You think the visas that they were supposed to allocate, for the reason that they have moved the dates so far, be wasted at the end of September of this year?
Yeah, I mean, there's a concern with that. They're trying to. I read an article because this is a recent trend, because when immigration was processing cases faster, there were no wasted visas, unused numbers. There was one article that I read by one of the textbook. His strong opinion is yes, they'll all be wasted, and that litigation should be filed to recapture those numbers. If that article is really good, it's long, so
Yeah.
Definitely.
We've been reading a lot of articles too, but I mean, we do not have a specific answer whether it's true or false.
Right, and I think some of that is going to also be based on the interpretation of how the visas are allocated. The reason I go into this particular article is because it's written by a well-known author who is well published, and I'm not saying that he is the first and foremost authority on it, but usually when he speaks, people listen. Just because he has made his practice in this area.
His interpretation?
Yeah, his interpretation of how the statutes are written and prior policies, how the government has behaved in similar years. He thinks that the visas will be wasted, but he also thinks that those visas are still there to be recaptured, which is why he thinks litigation needs to be filed by affected people. Remember, you have to have standing in a lawsuit. You have to have standing. You can't just walk into court. You have to be an affected party. So somebody that's been affected by this can go in, and he thinks there are great arguments to be made on that. So sort of bad news, but he thinks that with litigation, this can be fixed.
If this not recaptured, will be now just slow, again a slow trend.
Yeah, that's another position he takes. Is trends for the future. It's not captured.
That was been like that for 10 years.
Right, yeah. So it's hopeful, because I think after the Trump administration, and this is just my opinion on this, during the Trump administration, a lot more litigation has had to be filed to protect immigrants' rights. I think after 4 years of doing that, no one is scared to file litigation. You know, ever since the day one of Trump, remember the day he
And more litigation.
the first week he instituted the ban, he did it immediately, and you had people flying in, landing at the airport and not being allowed in, and then they asked, who can I talk to about this? The officer sarcastically said, talk to Trump. and you had these scenes on the news of practitioners standing out at the airports saying, I'm an attorney if you need help.
Yes.
So people aren't afraid after 4 years of filing lawsuit after lawsuit to enjoin policies of the prior administration. I think if this gentleman's position is correct, if it turns out to be correct, I do think litigation will quickly ensue. Like with the diversity visa last year, remember those were going to go wasted. Remember that? Last year, because of COVID, and I can't say anything about the pandemic because it's been horrible, especially for Indian people. The government was going to say we can't process these visas, and remember, if you don't process your visas by the end of the fiscal year, it's gone. That's clear. It's gone. And they had to have litigation, and even after the deadline, they were able to still process the visas. So I think you can make an analogy there. We did it with diversity visas. You can do it in other contexts too.
But yeah, any other questions?
All right.
Yeah, I'm pretty sure, since majority of our viewers have got your contact
They
information
can
now.
reach out directly.
They will probably email them to you.
Sure.
They will reach out. I mean, they probably text you and see when you're going to be available. Do you have a physical office by any chance up here in and around Memphis?
Sure, it's on the contact side.
It's on-
Yep, it's on the contact. It's my real office. I'm there. It's my permanent office. I have my stuff in there. It's where I do my work.
Thank you so much, Mr.
Thank you very much. I
A lot of
greatly
information. I'm pretty sure everybody took this that they didn't know from their not.
I enjoyed this very much. And thank you to everybody. I've been addressing other people, but thank you again. I'll sign off for now, but thank you so much for this wonderful opportunity. I had a blast talking about this.
Thank you, everyone. Thank you, guys.